Hi, I'm gregadamour, your host for Experts of Southern Nevada. I'm your real estate coach. Today I have a special guest, a well-known attorney in our community, Miguel Lopez, who I've invited to come and share some wisdom with us. I have worked with him personally, and my clients have worked with him personally, and found him to be a very ethical, honest, and competent attorney. And I'm very glad to introduce him today. We're going to talk a little bit about some of the real estate issues that are happening in our market today, and maybe some of the recent changes that we've seen. I believe the Assembly Bill 284 is undergoing some revisions or something.
Right now it is under review, and in our state, just a couple of years ago, back in 2009, our state legislature passed AB 284 that basically laid out the rules on how the banks can actually foreclose on properties. And as your viewers probably know, the number of foreclosures that took place prior to AB 284 going in effect in roughly October of 2009 was at a substantially high level compared to where things are at today. And part of the problem with the AB 284 is the banks now have a high hurdle to overcome to be able to do a foreclosure on a property. So the banks aren't really happy with it. Some state legislature people are not quite happy with it, and they're just looking to modify the law to allow foreclosures to begin rising to a high enough level to make the real estate market healthy, so to speak.
Help it to recover and maybe infuse more listings on the market and get some of those homes, I suppose, that are blighted or vacant and being deferred in the maintenance. I guess a lot of these homes that the banks are holding, I suppose once they overcome that hurdle, there'll be a larger inventory of homes, which will help the recovery.
That's correct. Right now, as you know, there's a shortage of homes that are in the market, but there's something called shadow inventory, which are all the houses that could be foreclosed. They're just not being foreclosed. And part of the problem is with this law, AB 284, it's preventing banks from being able to go forward. The part of the law that's preventing the banks from being able to foreclose is one of the requirements with making sure that the paperwork is correct before a foreclosure takes place, is that somebody at the bank has to sign a document. It's called an affidavit, attesting to the fact that they have personal knowledge for any particular home. And most businesses, nobody at the business has any personal knowledge. What they rely on are their business records. So here where the law might be modified, it's only to change that aspect of it to say that the banks can rely on their business records to go forward with a foreclosure. And if that were to happen, if it does get modified, then there could be a floodgate of homes that actually start to enter the market. Now, if that were to happen, as more homes become available on the market, I think prices could actually start to dip. And recently prices are increasing.
Yeah, they seem like they've spiked quite a bit as the market's been flooded by investors and local people looking to get back into the market. Some of the people that have lost their homes 2 or 3 years ago right now have restored their credit a little bit. They've completed short sales or overcome a foreclosure or maybe a bankruptcy. So there's a pool of buyers that are continually increasing, waiting on the sidelines, so to speak, that would like to get back in. And perhaps if they lower that hurdle a little bit and more homes come on the market, it just might help our community recover a lot. Is there any other particular hurdles that the banks, I don't know if they're lowering the hurdles a little bit. It sounds like they might be lowering it a little bit. And can we expect more properties to, say, be foreclosed judicially? Can you comment a little bit about the difference between the notice foreclosure, the standard one, and then this judicial foreclosure?
Sure. But before we go there, with this AB 284 that our legislature is supposed to be looking at this legislative session, even if they would like to modify it, likely it wouldn't go into effect until at least October. Okay, so banks have to deal with currently how to foreclose on a property. And really there's two ways. The standard way is called a notice foreclosure, and as you know, in a notice foreclosure, what typically happens is after a homeowner doesn't make a certain number of payments, and we'll call it 3, then the bank issues a notice of default. They have to record it with the county recorder's office. It has to be sent to the homeowner. It gets sent certified mail. But then after that, really what the notice is saying is if you don't become current on your mortgage, we're going to accelerate it. Once it's accelerated, you can't make a payment. But in that time frame between the recording of the notice and the acceleration, eventually they're going to file what's called the notice of trustee sale. And then they can sell the property. The time frame for that to occur is roughly 5 to 5.5 months. Okay, if you follow all the procedures. But there is a second way, and the second way is something called the judicial foreclosure. And in that avenue, none of the noticing requirements actually have to be met. That's basically a lawsuit that the bank files against the homeowner.
I see. So that would accelerate the process quite a bit and put some peril on the homeowner who is upside down or is maybe trying to resolve or reconcile his debt with the bank. How fast does the judicial foreclosure usually take?
The judicial foreclosure is actually rather quick. When somebody is served with a complaint, it's a complaint and a summons, it's basically a lawsuit. I mean, you've seen on TV or if you watch those shows that somebody shows up and they hand paperwork to the other person saying, you've been served. Right. Okay, that's basically what happens in a judicial foreclosure. When somebody's served with paperwork, they have 20 days to respond saying that they want to fight it. If they don't fight it, then the bank can actually wait the 20 days and submit for something called the default judgment. Once they have the default judgment, they can basically foreclose on the house. So you can see this could happen in less than 45 days from the time the paperwork's actually served. So it's a speedier process.
Right, very much so. Our viewers want to be mindful if you get a notice, especially a summons, which you should respond. Is it 20 days?
You have 20 days to respond
from
to
the time it's been mailed to you, or time you received it, I suppose.
That's correct.
So they need to contact an attorney then because they're involved in litigation there, and it's probably good to get some good counsel and experienced counsel like yourself that deals with this type of stuff.
It does make sense, even if it's just for a consultation where they can at least find out what the process is and what's actually happening. Because let's say as an example that one of your viewers is in the middle of a short sale. Okay, they have a buyer that's come forward, they've been negotiating with the bank, they're waiting for the bank to approve it, but their legal department starts a judicial foreclosure. If that happens, the short sale process comes to a dead stop.
I see. So it's quite a bit like the on the tables of turn a little bit. If a homeowner's in default and files a bankruptcy, the procedure that the bank has initiated comes to a stop until the bankruptcy's either been resolved or rescinded or completed. So it kind of works the inverse way, I would assume. Am I correct in that assumption that if the bank is turned it over to judicial foreclosure department, then the short sale completely stops and it's bad news for the homeowner?
Well, that's correct. And you know, a lot of short sales really from the time that the buyer comes forward to the time that the bank is going to agree to do it, it takes a lot of time. Well, sometimes the bank doesn't want to approve the short sale. They just don't know how to say, we're not going to do it. And now they're starting these judicial foreclosures. The judicial foreclosure procedure has been around forever. However, the banks have not taken advantage of using that method. And part of the reason is from a cost basis, the standard foreclosure way called the notice foreclosure, it costs less. So the banks didn't want to put out the extra money to do a judicial foreclosure. However, because of AB 284 that's preventing the banks from doing it the regular way, they're doing the judicial one because now the judicial one ends up being cost effective. I mean, if you take a homeowner that's living in their home, and for our purposes, we're going to say that they're not paying their mortgage. Well, eventually, the bank has to pick up some costs. I mean, forget the fact that they're not being paid. Eventually, they have to decide, do they buy homeowners insurance? Well, the bank will. They'll pay for it to protect the investment. Also, when real estate taxes become due, the banks again have to pay for the real estate taxes so that the government doesn't step in and sell the property at a tax sale.
Right.
So these costs, the banks are looking at it to try to find out, does it make sense now to do the judicial foreclosure?
I see.
And they are. It's becoming more cost effective.
It would seem that because of the carrying costs, if you will, for the taxes and the homeowners, and sometimes the homeowners associations, and just to maintain the structure of the property. Obviously, the vacant properties are subject to vandalism, and I'm not sure all insurance companies will pay out if there is a claim if a home's been empty for more than 30 days. So they might have to get riders to the insurance policy. So I can see where if this legislation we talked about earlier about the AB 284 doesn't, say in October, if they don't lower that hurdle, then maybe the banks are kind of put in a corner where they probably would just have to absorb the cost and initiate more judicial foreclosures.
Well, the banks already have.
Oh, they have?
I mean, just to give you an idea, all of last year, through my office, we might have seen 2 judicial foreclosures. Everything else was the regular notice transaction. But just in the last week, I've seen 5 or 6 new clients that have come in with their paperwork showing that they're being sued for a judicial foreclosure. And there's a huge difference. I mean, when somebody goes through the standard foreclosure process with a house that's underwater, there's going to be a deficiency. When you're doing a short sale transaction, the idea is to have the deficiency waived, meaning you lose the house, but you don't owe any more debt. Well, in a foreclosure, the deficiency is not waived. The bank's taken the property, there's a deficiency, and the bank has to make a decision. Do we pursue the homeowner for that deficiency? Well, some banks are, and some banks are not. Through a judicial foreclosure, really what they're getting is they're getting a judge, the court, to decide, yes, the bank can go forward with the foreclosure, and at the same time, they're holding the homeowner liable for the deficiency. So all the actions taking place all at the same time at once.
Wow.
When somebody gets the notice that they're being sued, right, they get the summons, it has it right in the paperwork what they're asking for. And what the banks are asking for is, 1, the property can be foreclosed. 2, that the deficiency that results that the homeowner is actually liable for. And 3, for the cost of bringing the proceedings, it's called attorney's fees.
Sure.
That they want to shift those attorney's fees onto the homeowner.
Oh, I see.
So there could be a substantial amount of debt that comes along with the judicial foreclosure. And that's if the homeowner doesn't fight it.
Right.
If they fight it, not only, assuming that they don't win, not only do they have those costs to contend with, but to fight it, generally speaking, they're going to have their own attorney's fees that they're going to have in fighting the case.
Right, and as the case continues, as the attorney's fees go up, obviously, and I've heard in some circles that big round numbers like $50,000 might be the type of fees that a bank may incur just to foreclose on a property. I don't know if that's in left field or right field, but is that...
I don't know for certain, but I would say that you're probably in the ballpark with that number.
Yes.
And again, those fees are going to be shifted to the homeowner.
Right, right. So our viewers really need to pay attention if they're in a default situation or upside down to contact Mr. Lopez or myself, and we can get some free advice or a retainer so you don't get caught up in the judicial foreclosure. It seems to me that the bank is probably, our banks are probably going to be resorting to that, because if they can't relax the hurdles AB 284 has put before them, they may just have to go ahead and go the route with the judicial foreclosure to get these properties back, put them back on the market. And we wouldn't want our viewers to have to be unaware of the consequences of something like that. So, and obviously the bank, it seems to me, would be able to alleviate or circumvent this AB 284 requirement to have personal knowledge once this goes before a judge, because the judge, I'm sure, can ask for a discovery and say, hey, well, obviously you've been making payments, you stopped making payments, we have a note in deed of trust recorded. This is you. Are you not Mr. Home Seller, Mr. Homeowner? And I think at that point, the judge will probably side with the bank. There's not much argument, really, that the homeowner who hasn't made the payments for some period of time can say, that he doesn't owe it at that point. Is that a correct assumption?
Well, this is great what you're bringing up, because what you're essentially asking is, how do you fight a judicial foreclosure? Mm-hmm. And before you can understand how to fight a judicial foreclosure, you need to know a little bit about how the court works. Mm-hmm. And if you think about this, when two parties are arguing and they're going before the judge in court, the judge has just got to decide who wins. Mm-hmm. Does the plaintiff win or does the defendant win? Here what we're talking about, does the bank win or does the homeowner win? Mm-hmm. Well, with everything that's going on, there's a way of measuring who's going to win. Mm-hmm. If we were talking about a criminal case, where somebody's going to go to prison, the standard that the judge uses is called beyond a reasonable doubt. That's a high standard to overcome. Mm-hmm. And this is why some people that might be guilty of a crime, they don't go to jail, okay, because the government can't overcome that hurdle. Mm-hmm. Here, we're not talking about the government, though. We're talking about a bank. Mm-hmm. So the level that has to be overcome is a lot lower. If we had to set this up, I'd say as a low standard, it's called preponderance of the evidence. Mm-hmm. A little bit higher standard is something called clear and convincing evidence. Mm-hmm. And then again, the highest standard is beyond a reasonable doubt.
I see.
The standard that the judge uses is actually a low one. For our purposes, we'll call it preponderance of the evidence. Okay. Now, what does that mean? Mm-hmm. Well, if you think about a scale, or, we look at from 1 to 100. Mm-hmm. When you show up in front of a judge, the scale is set at 50. Mm-hmm. Okay, it's like a coin toss. Who's going to win? 50-50.
Right.
And it's who can move the needle just a little bit so that the